Well, good morning, everybody. My name's Paul Marshall. Thanks for tuning in to our latest webinar, which is on the rise of the failure to prevent offence. We'll get started. As I say, the session today is on the failure to prevent offences and really how to avoid liability for third-party conduct. Your presenters are myself and my colleague Lisa Kinroy. We both specialise in corporate crime and investigations, so much of our time is spent conducting investigations where things have gone wrong, but from time to time we also are able to prevent things from going wrong through helping clients arrange for policies and procedures to be introduced which protect against the risk of breach situations. So today what we're going to cover is the birth of the failure to prevent offence, look at the current version of that offence which is live, that's the tax evasion offence under the Criminal Finances Act. We'll give you some practical advice about key protection measures, and we'll come into that thrilling end point where you as the jury will get to make a judgment about the innocence or guilt of a company. So the birth of the failure to prevent offence. I think we need to go back. So in the old days, companies didn't need to worry about failing to prevent things from happening. They just had to avoid committing an offence themselves. And the background to this was that in the old days, an organisation was treated like a human being, and that meant there was a slightly artificial pretense of like a real live person. There had to be a brain and a decision maker in the company, and you had to locate that person as having knowledge or intent for there to be criminal conduct by the company. So that brain needed to know that it had done something wrong before it could be guilty of an offence. And we talk about that as the operating mind and will, or the identification principles. You had to find that senior person before the company could be guilty. And that meant that if you were a large company in particular, ignorance was bliss. If you didn't know about something, it couldn't hurt you. And the least said about bad things, the soonest it was mended. So really very difficult for prosecutors to bring cases against corporate entities, particularly complex corporate entities, and really not good for corporate governance because it suited a business to think, let's just turn our face away from this. A blind eye here will work nicely for us unless someone can show we had deliberate knowledge and intent. We're going to be okay here. So that was the old world and probably not the most effective for corporate governance. And then the new world which came in was the failure to prevent offence. And the background to that is something like this. I almost imagine prosecutors and government officials having a discussion saying, right, let's not make it necessary for the controlling mind of an organisation to be embroiled in the wrongdoing. Instead, let's just put a general duty on organisations to prevent wrongdoing in the first place. And let's make them guilty if something bad does happen and they failed to prevent it from happening. And that gives you the two benefits, the reverse of the last position. First of all, it's easier to prosecute the organisation because it has a duty to comply with. If it doesn't comply with that duty, it starts from a guilty position. And equally, the sort of good governance point is then met because if you have this failure to prevent approach, it means that responsible businesses, responsible organisations will not only look after themselves, but they'll also police those they work with. So they'll make sure their employees, their agents, their contractors and others that work with them are all doing the right thing because that responsible entity knows that if it doesn't police others, it may also be guilty of an offence. So that's the starting point. The model for this, and I'll say in a moment, it started with the Bribery Act, I suppose, and we can see it now in the new criminal finances offences. The model is something like this. The organisation, which we'll call them the good organisation, is guilty of a secondary offence if it failed to prevent the associated person committing a primary offence. Now, in all these scenarios, I imagine, because that's our experience usually, the organisation is actually doing the best it can, and the associated person is usually the bad penny or the rotten apple. And the problem for the good organisation is that it's guilty of an offence if that associated person commits the primary offence. And the organisation can avoid that criminal liability if it can show that it had in place procedures designed to prevent the commission of the primary offence. In the Bribery Act, those are called adequate procedures. In the Criminal Finances Act, we're talking about reasonable prevention procedures, but it comes to the same thing. So the step change here, as you already have picked up, is that it puts this failure to prevent offence, shifts criminal responsibility away from the bad actor. They still have liability, but it also puts that responsibility on the organisation, the good organisation. So they're responsible for the criminal conduct of connected third parties. But there is, of course, the good news story, which we'll come to in a second. Before we get to that, there's an international reach point, which first of all came in with the Bribery Act, which we're now seeing again with the Criminal Finances Act offences. And this is often where clients and other organisations see the jeopardy arising. If you're in the UK, operating lawfully in the UK, the Bribery Act and now the Criminal Finances Act put you on the hook for conduct which happens overseas in your name, effectively. So where there's wrongdoing overseas, it's now increasingly likely or possible that that overseas conduct can come home to roost and be prosecuted in the UK. So that's the international reach element. And the prototype for all of this, as I say, was the Section 7 offence in the Bribery Act, which created that first example of failure to prevent. So at this point, I'll pass on to Lisa, who is going to bring us up to date by talking about the failure to prevent offences that have came through with the Criminal Finances Act. Why we've picked the Act is, and Lisa will explain this more in a moment, there is some real momentum behind the Criminal Finances Act right now in terms of the HMRC approach to investigation, and we'll hear more about that now. Lisa.
Thanks, Paul. So we're describing these new failure to prevent offences imposed under the Criminal Finances Act as the next generation. And as Paul was saying, that really builds on the Bribery Act. So looking at the essential elements of an offence under the Criminal Finances Act, we'll come on to look at the offences themselves in more detail a bit later on, but if we start with the essential elements of an offence, stage 1 is the criminal evasion of tax by a taxpayer under existing law. Stage 2 is the criminal facilitation of tax evasion by an associated person of a relevant body, and stage 3 is that there was a failure by the relevant body to prevent its associated persons from committing the criminal facilitation at stage 2. And where Paul was speaking earlier about a primary offence and a secondary offence, stage 1 is essentially that primary offence. There's an offence by a taxpayer who has evaded a responsibility to pay tax under existing law. And stages 2 and 3, that's the secondary offence. So that's the offence that a relevant body can be prosecuted for. And what we see here is that there needs to be an underlying or predicate offence at stage 1 in order for a relevant body to be prosecuted for an offence at stages 2 and 3. But as Paul was saying earlier, there is a good news story, and that is that similarly to the Bribery Act, there's a complete defence if an organisation can demonstrate that it had reasonable prevention procedures which are designed to prevent that stage 1 offence. And that's a recognition that mistakes do happen. This isn't a zero failure regime. So provided that a relevant body meets that test of having reasonable prevention procedures, it may avoid a prosecution under the Act. And as Paul was saying earlier, there is this sense of real momentum in terms of prosecutions under the Act at the moment. So if we go back to the first quarter of last year, this is about 18 months after the entry into effect of the Criminal Finances Act, and we're beginning to see the first set of statistics coming through. So an Ipsos Mori poll published in March 2019 looked at business awareness and responses to the new provisions under the 2017 Act. And essentially what it was looking at is to what extent had business behaviour changed as a response to the 2017 Act. And you'll see there a number of stats on the slide. Just picking out a few of them, according to the Ipsos Mori survey, only 25% of businesses were aware of the new offences under the 2017 Act, and only 24% of businesses had undertaken a risk assessment. We're going to look at what is required in terms of reasonable prevention procedures a little bit later on, but one of the key elements of reasonable prevention procedures is undertaking a risk assessment and understanding the particular risks which arise for individual businesses and their own individual operations. Only 20% had made changes to their operations directly in response to these new offences, but 11% said that they were planning to introduce changes or make further changes in the next 12 months. And only 8% had organised training or staff communications updates on the offences in the last 12 months. And that final point there, that's another essential element of reasonable prevention procedures, which is communication and training. So not perhaps the statistics that the government and HMRC might be hoping to see as a response to the survey. But if we move on to the next slide, we can have a look at what the most recent set of statistics shows us. So HMRC published an update earlier this year at the end of February. What they were saying in that update was that there were 30 potential failure to prevent cases underway, but that broke down into 9 live organised investigations and rather curiously described 21 opportunities which were under review. So not yet live investigations, but instances where concerns had been raised in HMRC were looking at those with a view to investigating further. And the spread of cases ranged across a number of different business sectors. Those identified in the update include financial services, which HMRC and the government, of course, see as a key sector for the potential for concerns to come up under the 2017 Act. Oil and gas, construction, labour provision, and software development. And the concerns ranged from relatively small businesses to what were described by HMRC as some of the UK's largest organisations. So a real spread of concerns, both according to business sector and according to size of business. And the update concluded with this statement at the bottom, which shows that HMRC is actively looking at criminal conduct arising under the 2017 Act, and is clearly motivated to take action where there is conduct which contravenes the Act.
Thanks, Lisa. So a picture there of a regulator, HMRC, which has some teeth and has some motivation and drive here. What we thought we would do is try and bring the excitement of tax evasion to life with a pretty basic case study. Apologies for those who've got specialist tax expertise on the webinar today, and for those who are fans, I suppose, of Robert Louis Stevenson also, because this case study really does mangle both of those a little bit here. So we called it Pieces of 8, and it begins once upon a time, and we have an entity, James Hawkins Limited and the Treasure Island. So James Hawkins Limited is a UK incorporated mining company. All of this is all entirely fictitious. I suppose elements of this are things we've seen in previous cases, but all of this is entirely fictitious. There is no James Hawkins Limited UK mining company, just to be clear. So this company, this fictitious company, provides mining and extractive services to clients around the world. It's identified an opportunity in the mineral-rich land of Hispaniola, and that's often referred to as the Treasure Islands, that mythical land of Hispaniola. The government of Hispaniola is licensing controversial extraction works on the boundary of a site of historic interest, and the government is requiring all license applicants to include local content. So James Hawkins here has identified a local mining operator, Ben Gunn Incorporated, as its preferred partner. Now, Lisa, maybe if you can put the entity James Hawkins we're talking about, put that back into the Criminal Finances Act context for us.
So this is looking at what kinds of organisations can incur criminal liability under the 2017 Act. And what the 2017 Act says about that is that only relevant bodies can commit an offence of failure to prevent the facilitation of tax evasion. Relevant body is defined to include incorporated bodies and partnerships. It could extend, for instance, to a public body where that public body has been incorporated under the Companies Act. But essentially, we're looking at incorporated bodies and partnerships. It does not include individuals, so there's no offence under the 2017 Act for which an individual can be prosecuted, although of course there is the separate offence for an individual who's committed who's committed a primary offence. They could be prosecuted separately for their own individual conduct. Applying that to our story, we have James Hawkins Limited. That's a UK incorporated limited company incorporated under the Companies Act. So it is a relevant body for the purposes of the Criminal Finances Act, and it is exposed to potential liability under that Act.
Great. So taking the story forward, we introduced Long John Silver Enterprises. So Ben Gunn, this is the local company in Hispaniola, indicates that is interested in entering this joint venture opportunity with James Hawkins, but their CEO, Ben Gunn's CEO, explains, well, as one of only 3 mining operators in Hispaniola, you'll understand that we have many opportunities. Therefore, to agree to join with you, we must be happy with all aspects of the arrangement. And the CEO goes on to explain to James Hawkins that the management of any joint venture would require to be by a Hispaniola accredited agent, but reassuringly says, have no fear, we know just the consultant for this role, we must have Long John Silver Enterprises. I was quite pleased with Silver Enterprises as being part of this case study, but anyway, right. So James Hawkins Limited has some experience with overseas consultants. They've no knowledge of the Hispaniola market, and they agree to follow Ben Gunn's recommendation and appoint Long John Silver to manage the joint venture. And Lisa, can you help us with how does Long John Silver fit within the scheme of the Criminal Finances Act?
Sure. So as we saw earlier, one of the essential elements of an offence under the 2017 Act is that there is a person who acts in the capacity of a person associated with a relevant body who commits the facilitation element. So that stage 2 element that we saw in an earlier slide. Associated person is defined broadly within the Act. It will include, for instance, employees, agents, other persons who perform services for and on behalf of a relevant body. So that could include, for instance, professional advisors, commercial intermediaries, commercial agents. So it's a broad application and extends both to persons who are employed within the company and persons with whom the company contracts with. Whether or not a person is performing services for and on behalf of the relevant organization, so the nature of the relationship and the name of the appointment given to the person is not necessarily determinative. It's looking at the whole range of relevant circumstances which apply in the case. But here, back to James Hawkins. Unfortunately for James Hawkins, as we'll see, Long John Silver, he is employed as in the function of an agent. He's an associated person of James Hawkins Limited. So let's see how James Hawkins goes about setting up that relationship.
Yeah, so we've now have the appointment of Long John Silver. So Hawkins and Ben Gunn, they're finalising the joint venture proposals as part of the licence application, and they turn to the appointment of Long John Silver. The Hawkins legal team dusts down its standard terms to be used for the appointment of overseas consultants, and they know there'll be some need to tweak that to align this to the Silver role here. And they send their terms to the consultancy group, the Long John Silver Group, for review and signing. And they're expecting this to come back with a couple of tweaks. But they're taken aback at the scale of revisions that they receive in response. And their draft terms are substantially slimmed down, with provisions designed to protect James Hawkins removed. And some of the key removals here, the revised draft has struck out the requirements for compliance with law and also the requirement for Long John Silver to comply with James Hawkins' business ethics policy. That's often what you would see in the appointment of an overseas consultant, that requirement to comply with your business's policies. All of that's been ruled out here by Long John Silver. And the Hawkins team query these revisions, and Long John Silver emboldened explain, well, this is the standard approach. In Hispaniola, Ben Gunn have never had a problem with our appointment terms in the past. If you don't like what we were suggesting, we can report that to Ben Gunn, but we can tell you right now, they won't be pleased. The commercial director at Hawkins, who perceives his neck to be on the line if this all falls through at the 11th hour, he says that there's no time to get sidetracked. We don't need to get bogged down in these details. Let's just get these terms accepted. Crucially, no referral to any senior team on that point, and not even a review by a contracts team of no review of the changes to the terms, and the commercial director signs off on that appointment. We move forward to look at Long John Silver's innovative approach. So Ben Gunn and Silver are on board, and the joint venture arrangements are complete, and the application for the license is successful. Over the first year, the joint venture is remarkably successful. The profits for that year are significantly higher than were budgeted for by James Hawkins Limited. And the Hawkins team they're delighted, but they're also a little bit curious, and they speak to Ben Gunn, their local partners, and they say, well, this is why we recommended Long John Silver. This is what they can do. They've got a novel and innovative approach that helps to lower project costs. The Hawkins commercial director, who had signed off on all of this and remembers the deletions from the Long John Silver appointment, I think he's getting a wee bit queasy now, gets in touch with his opposite number at Long John Silver to understand more about these innovative approaches. And Long John Silver's very proud team identified two savings. There have been these fantastic first-year profits have been secured largely as a result of two innovative approaches. First, the archaeological VAT exemption, which I was very tempted to call the Indiana Jones VAT exemption, but I didn't. And this is, in Hispaniola, no VAT is payable on equipment hired for use in connection with archaeological digs. And Long John Silver say, we recovered a substantial VAT rebate by declaring the cost of the mining equipment under that scheme. So they're very pleased with that. James Hawkins, commercial director, is a little bit puzzled. He's thinking, but the equipment was not being used in connection with any archaeological dig. Long John Silver, they're clever guys, their response, yes, but you could argue that since our site is so close to a site of historic interest, that really we should be entitled to that archaeological dig exemption. And that was the rationale in which they made that claim. Second innovative approach, pirate workers. The Silver team, this is an old trick, but it's worked well for us in the past. In addition to the workers employed direct by the joint venture, we were able to secure a group of off-book pirate workers who would work through the night for a fraction of the standard wages. I sort of imagine these guys with pickaxes, and wet peg legs and such things. And the Hawkins commercial director thinks and then asks, that wouldn't be allowed in the UK. Is this legal, this pirate workers thing? Is this legal in Hispaniola? And Silver's team, well, no, but we put those workers through as project expenses, and so made a significant saving. We also avoided any income tax or national insurance contributions that are required to be made there. And you can feel the commercial director's stomach going through the floor here. So Lisa, taking that, what we just heard from the Long John Silver management of the joint venture and bringing that back into the offences under the Criminal Finances Act, could you help us?
Sure, of course. So the Criminal Finances Act imposes two corporate criminal offences. They came into effect on the 30th of September 2017. Two offences shown on the slide there. The first is the failure to prevent facilitation of UK tax evasion. And this is an offence where the conduct involves a tax evasion on UK revenue. So it's UK conduct and it's a fraud on the UK revenue. And that offence is punishable in the UK courts under the Criminal Finances Act, regardless of the place of incorporation of the relevant body. So where the offence is a fraud on the HMRC, the UK courts have jurisdiction, and UK authorities can prosecute that in the UK. The second offence, and this is what Paul referred to earlier as international reach. This is the failure to prevent the facilitation of foreign tax evasion. So this is where the conduct involves a tax evasion offence in a country out with the UK. As we say on the slide there, there's a requirement for dual criminality. So the conduct must be criminal both to the standards of the relevant foreign law and by the standards of UK law. So if it's criminal in both jurisdictions, the relevant body, if it has a link with the UK, what we're calling a UK nexus, it can be prosecuted in the UK courts. So for it to have a UK nexus, we're generally looking at incorporation within the UK or operations within the UK. And applying that to James Hawkins, what we have here is obviously there's a foreign element to the story. So stage one, there's a foreign tax evasion perpetrated in Hispaniola by the JV. At stage two, that tax evasion was facilitated by Long John Silver as associated person of James Hawkins, and at stage three, Long John Silver was associated with James Hawkins. But here, just taking all of that together, James Hawkins is incorporated in the UK, so it has the relevant UK nexus. And what we're told is that the offence is criminal both by the standards of the law of Hispaniola and by the law of the UK if it were to be attempted in the UK. So things are not looking good for James Hawkins. However, this is the good news story that we've been referring to. This is the defence of reasonable prevention procedures. So where a company, a relevant body, can show that it has taken reasonable prevention procedures, then there's an opportunity to avoid prosecution. And the defence is based on the following 6 principles listed there on the slide. Risk assessment, that requires the relevant body to carry out ongoing written risk assessments, which are designed to assess the risk of associated persons committing a tax evasion. The prevention procedures must be proportionate, so they should be realistic, and proportionate to the level of risk and the nature of the risk identified by the risk assessment. There's a requirement for top level commitments. So there's a requirement by the top level management within the relevant body to have a zero tolerance to tax evasion, and for that to be communicated both internally and externally. Due diligence, that requires the relevant body to do its diligence, essentially, to look at associated persons and understand the risks of doing business with them. Communication, including training, that involves essentially the embedding internally, making sure that both staff and business partners understand the risks and that they understand the prevention procedures. Monitoring and review, keeping under review prevention procedures, making sure that they remain appropriate to the company's business and operations, and monitoring the conduct of business associates. So turning back.
We'll move on, yes, to applying that to James Hawkins. And Lisa, I'll just remind the audience at the moment, this is the crucial moment for the audience. If you've not been paying attention until now, this next slide is the crucial slide to pay attention to, because the good name of James Hawkins turns on your verdict in a moment, everyone.
So running through the principles, this is where we assess the conduct of James Hawkins to understand if the defence of reasonable prevention procedures might be available to the business. So risk assessment, one of the elements of a risk assessment is to assess the risks of a particular business partnership. As we saw, there was no real risk assessment in connection with the Ben Gunn Long John Silver engagement. Proportionality of risk-based prevention procedures. Well, James Hawkins was entirely right to ask Long John Silver to agree to comply with its business ethics policies, and wait for it, shame they didn't stick to their guns on that. Top level commitment. Here again, there's a failure to maintain a top level commitment because we see the commercial director, he's feeling his neck on the line, and he feels pressurized to get the Long John Silver appointment set up. In terms of due diligence, the only due diligence carried out is the appointment of Ben Gunn on a recommendation, but there's no broader assessment of Ben Gunn, of Long John Silver. In communication, including training, we don't see any evidence of training. The business ethics policy was at least communicated to Long John Silver, so that's something. Monitoring and review, what we're saying here is plenty of room for improvement next time.
So taking all of that together, now for the audience, imagining, again, we're playing fast and loose with the criminal justice process and the speed at which it will run. But imagine we've got to the stage of our prosecution has been raised, it's gone before the court, we've had the trial, all the evidence came out in the way we've just heard, and the business Hawkins Limited is saying, yes, there was this failure on our watch, but we did have prevention procedures in place, so we do have a defence, and that's what's been put to you as the jury. So the choice for you is, if you do believe that James Hawkins Limited has done enough to bring itself within the defence of having in place reasonable prevention procedures, if you think they have achieved that, then you would find them not guilty. If you think that they haven't done enough, you would find them guilty. So if you could all start, if you could open up your Q&A bar and indicate whether you're going to find them guilty or not guilty, we'll start to see some votes coming through. We're seeing, there's some really aggressive jury members here. Hang 'em high is one so far. As we run through, I'm looking for anybody, anyone with any sympathy for James Hawkins here. Almost of that, we need that film 12 Angry Men from back in the day, where I think you had Peter Fonda or somebody, one of the Fondas in a white suit, convincing a bloodthirsty jury that people were not guilty. But clearly there's nobody in this chat room, or this Q&A I should say, nobody in this Q&A with a white suit who's going to find Hawkins innocent. No, that's a pretty, oh wait, one anonymous attendee who's not given their name, probably for fear of retribution, has found Hawkins not guilty, but everyone else, increasingly angry, just wanting me to stop. Yep, everyone else has found Hawkins guilty. I think, Lisa, what do you think? It's quite difficult to argue with that.
Pretty overwhelming, I think.
Yeah. So we're just coming to the end. If you've got any burning questions, please, now that you've put down your hangman's noose, pick up your pen and put any questions you have in the Q&A chat for us. But just as a final slide before we get to that, if you were the company Hawkins here and you were found guilty of that failure to prevent offence, you're looking at, there's no limit to the financial penalty that could be imposed for a guilty verdict here. You're also looking at the risk of confiscation orders, so that any benefits that you obtained from your criminal conduct or from the criminal conduct here could be recovered. The convictions, this is really an HMRC point, convictions may require disclosure to regulators both in the UK and overseas, and I think the real jeopardy for a lot of organisations would be, is it going to prevent you from bidding for work in future? I mean, that's one point. The broader point is, as we all know, is that reputational risk of once your name as an organisation is attached to something like this, whether it's tax evasion or other compliance failures, there's that real impact on reputation for a period of time. One of the, just an interesting point to finish with, and we'll see where this goes. This is something self-reporting, which follows in the footsteps of the Bribery Act here, self-reporting and the use of deferred prosecution agreements. So this is the idea that if, as a business, as an organisation, if you find out that something has gone wrong, then you have the ability to investigate that yourself and then approach the authorities and say, we have found this, we were not happy, like Hawkins here. We didn't prove any of this, but we do see that our procedures failed here. We let ourselves down on this, but we're telling you this story. Please don't prosecute us for the failure to prevent offence. And what HMRC have said is that that type of approach will be viewed as one of the points that shows that you have reasonable prevention procedures in place if you walk forward with your hands up, so to speak. Of course, the corollary of that would be if you do find out something and you don't make a sort of confession of all of that, if you don't make an admission of all of that to the regulator, then there's a risk that you will be found not to have reasonable prevention procedures in place if you had knowledge and didn't flag this. So a bit of a carrot and stick is one way to put it, but certainly a clear expectation that you will go and tell your stories to the authorities. If you do that, of course, I'm going to say take good legal advice before you do that. So I'm looking down some of the questions that have come in just as we close here. First one is, what level of due diligence would you suggest would be appropriate? External reports. It will be very fact specific. So if you were this fictional or fictitious country, Hispaniola, if Hispaniola was a country with a poor rating, let's say from Transparency International, if there was a high risk of corruption and tax evasion already existing there, and so you're then looking at engaging agents in that jurisdiction, then yes, one of the steps you would look at here would be a report on the agent before you were going to appoint them, you could do some serious investigation in. Equally, if it was a global agency, I need to pick my words here carefully, if it was a global agency with a good reputation who just happened to be engaging in Hispaniola, and you'd worked with them previously, or you had other business connections who'd worked with them previously, a lesser form of diligence might be necessary or might be appropriate. The jeopardy every time, though, is it's not what a reasonable commercial organisation thinks is appropriate due diligence. The tough point here is what HMRC or the equivalent regulator thinks is appropriate due diligence. So you should always err on the side of more rather than less insofar as you can. Another question which came up, Lisa, which maybe you could pick up the question is, what's expected by way of top-level commitment? Should there be a specific identifiable director responsible for compliance?
Yeah, so in terms of top-level commitment, what HMRC have said is that top-level commitment both within the business and externally. So both staff within the business and commercial agents, anyone the business engages with, should understand exactly what the business expects in terms of business ethics and commitment to not to engage in tax evasion. And that needs to come from the top of the business. So it needs to be clear that the top level of management is advocating that. Probably is a good idea to have someone accountable in terms of named someone who's promoting that, both within the business and to those with whom the business engages with. But it needs to be clear throughout the business in terms of staff within the business and also externally.
Yeah, there's the sort of dark side of that question as well. The top level commitment question. One thing is, and we sort of hinted at this in the presentation, where you have the commercial director here, and sorry, we didn't get to the level of giving everyone names, but if we're giving the commercial director a name, where that person it has got, and it's quite a common choice, with the choices between, quote, what we might call, quote, the commercial way forward here, and the other option is the sort of more boring compliance way forward here. One is more risk taking, one is more risk averse. The top level commitment, the leadership in the business will help people's moral compass in that. So if you feel like the director did here, this is such an important project, I must get this over the line, there is no breathing space or room for maneuver to check these things out. In that situation, the top level commitment is probably failing, because it has had the opportunity to reassure people and say, we believe that compliance with tax evasion is important. So if you've any doubt, you should pause. And that's an easy message for all of us, isn't it? If there's any doubt, just pause and take a breath and speak to someone. But if people think that they can't, or it would be not in their commercial interest to do that, and so they press on and take the risk, that's a good example of the top level commitment going wrong. And on that, identifying a relevant person is what we've seen. Lisa and I, a few others in the team, have been working on some investigations recently, and the common theme is responsibility falling between stools. So different parts of an organisation, all of these parts could in some way have some responsibility, whether that's someone who's a business development responsibility, or someone with a regional responsibility. But at the end of the day, when it goes wrong, they are all pointing at each other and saying, that wasn't my responsibility, it was someone else's. So the first step is to make an individual or a group responsible for compliance in a given scenario. Just scrolling down to see if we have any other. There's someone repeatedly voting guilty. Coming back in with more and more guilty votes just to get it right. No. Last couple of questions. One is, what should we do now to make sure we have the right policies and procedures in place? As you've got the feel from the slides, the failure to prevent risk does turn on third parties to a great extent. So a lot of the compliance steps you have hopefully taken when the Bribery Act came into force around managing relationships with third parties, whether it's a business ethics policy or whether it's a third party risk policy, taking that as your starting point and developing that out to deal with tax evasion is quite a neat way to get the ball rolling. And another question, how do we go about making a self-report when there's concern something has gone wrong within the organisation? So we talked about that a little bit at the end of the session there. The key thing here is to get the full story, know the entirety of the story, and then make sure that when you go to the regulator with that, you've got legal advice, make sure you go to the regulator, you've got to make a choice. You've either got to go with the full story and be credible about that, or don't. The worst thing to do here is to try and present a half version of events to a regulator and think that that will be enough, because that damages credibility, and all you've done is give the regulator the ability to build a case against you without any of the goodwill that comes with that. Lisa, just on that last point about self-reporting and how would you do that, do you want to talk maybe just for a moment about how you would set up an investigation, a self-reporting investigation? What would be the basic building blocks of that?
So our practice when we commence an investigation is to start by drawing up a terms of reference, and that sets out what's understood in terms of the concern at that point, and identifies the relevant people that we think we're going to need to speak to, the documents and other material we think we're going to need to recover and review, and what we tend to do is set out a phasing of the investigation, and it will depend on the nature of the concern and the information that is available, but it will generally start with a document recovery exercise. We'll recover the documents that we think we need to see, review the documents, and from there start to identify the people that we think we need to speak to, and the questions that we think we need to ask.
And what's nice on that, sorry, what's quite nice about that, because that sounds like quite a heavy lifting exercise, but the quite nice thing for the organisation there is if you're able to say to a regulator, either if they've started an investigation or they're about to start an investigation, if you're able to say to them, we're aware of this, we are investigating, and we have a process in place, that there's a discussion to be had, but that's a very good way to try and maintain some control over the process, as opposed to be into that reactive place immediately and have a substantial amount of business disruption. So showing there's quite a sophisticated regime or sophisticated process in place to manage your own investigation, usually with external counsel, is a very good way to basically get the regulator off your back for a moment and allow you to get on with working out what has actually happened. Okay, we're coming up towards the hour, so I think we really wanted to stop, give you 10 minutes to get a coffee before you have to do what you have to do at 12. Just checking if there's any final questions. There's a final question. Does the relevant body, the UK company, have to profit from the third party's wrongdoing? So just on that point, it probably profit wouldn't be the way I would put it. It's where that third party is performing a service for or on behalf of the UK body, then that is enough to clinch the criminal liability here. So it doesn't need to be the case that the UK body actually gets more money in its pocket at the end of the day because of the third party's actions. If the third party, who we call the associated person here, but if the third party and the tax evader, let's say, if together the two of them are committing or involved in the tax evasion, it doesn't need to benefit the relevant body. No, the relevant body was in a position to prevent it because the associated person was working to their instructions and didn't manage to do that. Good. I think if, unless there's any other burning questions, I'm going to take that as a good time to close the session. Thanks all for joining today. Thanks to Lisa for presenting with me. We will make the presentation available to all of you, both traditionally and the thrilling webinar itself, once available, and we'll speak to you again soon. So again, thanks for joining.